Hi everyone, my name's Tina and I am the Head of Employment at Wright Hassall. I'm joined today by a solicitor in my team, Gemma.
Hi everyone.
And today we're going to talk about bullying and harassment. This is such an important topic and I have been working really hard in the background to campaign for workplaces to end bullying and harassment. So just to give you a little bit of a background as to why I feel strongly about this, as an employment lawyer, I regularly receive employees' complaints where they are alleging behaviour from other people which amounts to bullying and harassment. But unfortunately, they have left the situation to get to a point that they feel they need to leave their employment or it's actually made them very unwell. And I also receive contact from employers who proactively want to deal with a situation that's arisen in their workplace and don't know how to deal with bullying and harassment. So that got me thinking about doing a survey. And recently I did undertake a national representative survey of 2,137 people. And I asked them a few questions. And the findings were absolutely shocking. So just to summarise the findings, my survey revealed that 2 in 5 people experience workplace bullying and or harassment, with 62.5% of those choosing not to report it. Almost 1 in 2 people believe that their workplace tolerates discriminatory banter. 1 in 12 people admitted that their workplace often tolerates discriminatory banter. 1/3 more women experience bullying and harassment from a co-worker or supervisor than men. And as a result of the behaviours, 33% of people said that they wouldn't recommend a job at their organisation. So those stats were absolutely shocking. And I even asked what were the reasons for not reporting bullying and harassment, because that was a common theme that seems to come out from my survey. And there was 3 main reasons. 1, employees lacked confidence. And the third one, which actually shocked me the most, is that they believed that nothing would be done. So having conducted that survey, I've been sharing lots of my posts on LinkedIn because I've really wanted to make some noise about ending bullying and harassment and putting the stats in the spotlight. And then following from that, I campaigned for an End Workplace Bullying Day on the 25th of October. And I've launched a free helpline for employees and employers for a month because I really want people to speak to me, to ask for help, whether you're an employer or an employee. So the reason I'm focusing on bullying and harassment in this podcast is because these stats that I have obtained from my survey need to be heard outside of just Wright Hassall. People need to know that bullying and harassment is a real issue. So you might be asking yourself, what is bullying? And I know that you will have an idea because most people do, but actually there's no legal definition of bullying. But in order to claim that you have been bullied from a legal perspective, there's behaviours that would tantamount to bullying. So Gemma, do you want to just give a brief summary of what we say bullying is, or what we see on all different websites, how bullying is described in the workplace?
Yes, so as Tina said, there's no legal definition of bullying. It can come in many different forms. It can be verbal, it can be in written correspondence. One we commonly see is on social media or potentially even sort of private messaging systems that aren't necessarily private, given the fact people involved in those can provide those messages and share them more widely. But in terms of bullying, sort of the behaviour, it could be offensive behaviour, intimidating behaviour, malicious, insulting, or even behaviour intended to humiliate someone. It could be abuse of authority, especially in potentially supervisor relationships. But essentially, it's behaviour that is potentially belittling to another colleague in the workplace And often it has the effect of causing that employee stress or anxiety as a result of the behaviour they're suffering. And there's also an array of claims under the Equality Act 2010, which relate to discrimination, so potential claims for direct discrimination, victimisation, and one of the key ones we see is harassment. So that does have a legal definition under Section 26 of the Equality Act 2010, and that essentially is unwanted conduct that an employee receives either related to a protected characteristic, which has the purpose or effect of violating their dignity or creating a intimidating, hostile, degrading, humiliating or offensive environment. Or it can be as a result of an offence of sexual nature, which again has the effect of violating their dignity. Or there is a third one, which is less common, but as a result of advances of a sexual nature and the employee rejecting those advances if they're treated less favourably as a result, again, that can be a claim of harassment. So whilst there's no bullying claim, there are definitely a number of claims that employees need to make sure they're aware of that they could issue in an employment tribunal as a result of that behaviour.
Thanks, Gemma. So you would have just heard Gemma mention the protected characteristics, and this is the protected characteristics comes up in employment law a lot because the law defined what is a protected characteristic. So, and there's a few, and let me just tell you what they are. So the first is age, then we've got disability, we've got gender reassignment, race, religion or belief, sex and sexual orientation. So what often happens, unfortunately, is that when comments are made or when behaviour is inappropriate, it can often relate to someone's protected characteristic. And if that should occur, that's actually discrimination. In terms of bullying, as Gemma mentioned, it can take many, many forms. And it very much, the person who is at the end of that bullying, sadly, is the one that has the feelings as to what they're receiving. So Gemma mentioned it can cause stress, but actually, lots of employees also, unfortunately, develop anxiety and depression. They take time off sick. It can also result in there being a low staff morale in the organisation. It can result in employees just leaving and not actually ever telling an organisation why they've left. And that's a real issue for me because that means that employees are leaving having felt bullied, harassed or discriminated, but they won't tell their employer. And that is something that I'm really passionate about addressing because that's got to stop in my view. Some common examples of bullying behaviour that we've come across is, for example, when employees are set unreasonable demands, so they feel like they've been set up to fail. Derogatory comments, that's the most common one. People will say things which makes an individual feel a particular way, might make them feel humiliated or belittled, as Gemma had mentioned. Picking on an employee for poor performance, which is unwarranted, that's generally a common example as well. And unwelcome advances, and that can be sexual advances as well, that can all constitute bullying. So whilst there is no legal definition, you only need to Google the word bullying and you'll get lots of examples as to what bullying can be. It's really important, as I've said a few times, that bullying and harassment is tackled in the workplace, not least to prevent, employees bringing claims, but actually to prevent that behaviour. The fact that employees can bring claims, and they should bring claims, is a separate issue. What we actually need to do is be proactive and not react to bullying occurring, but have things in place where, one, employees feel they can report, and two, employees that are displaying bullying, discriminatory or behaviour that's harassment are accountable and they are held to account. So Gemma, the next question I wanted to just cover off for the purpose of this podcast is, what can employers do if an employee complains about bullying, harassment or discriminatory behaviour?
So, as Tia mentioned, there's a lot that employers can do. And I suppose before we even get to the complaint of bullying and harassment arising, what employers want to make sure they do across their workplaces have enforced policies that cover equality and diversity in the workplace, as well as anti-bullying and harassment, because that explains the employer's position on calling out such behaviour and not tolerating it, and what it needs to be clear in those policies that if such behaviour is identified and brought to the company's attention, that appropriate disciplinary action would be taken by the company, and they will take these matters seriously, because that is going to encourage more reporting. And as the survey showed, as Tina said, that is a key area that needs to be improved within the workplace. So having the policies is great. What they also need to do is have training, and not just one-off training. This should be regularly undertaken so that employees are aware of what behaviour can amount to bullying, harassment, discrimination in the workplace, and so they actually make sure that they are aware of that and they can implement that in the workplace going forward. If there is a claim that's brought, an allegation by an employee that they've suffered potential bullying or harassment in the workplace, then what they should ideally follow is the grievance procedure that they've had from their employer. Now, again, that should be a written procedure that all businesses have in place so employees feel comfortable knowing what they should do. The first instance might be for them to have an informal discussion with the employee, work out what the issues are and see if there can be an informal resolution. Now, that's not always going to be an appropriate resolution, but if it can help, that can bring a swift resolution to matters and hopefully going forward avoid any further conduct of that nature. But if that's not appropriate or it doesn't have the desired effect, then what should happen is the formal grievance procedure needs to be followed, a full investigation of the allegations raised by the employee. So speaking to them, making sure you fully understand what they're saying, their opinion, and how it made them feel. And then you need to take investigations as well as necessary. So that might be investigating any written documentation or correspondence, speaking to any witnesses that are involved, and making sure that you complete a fair and thorough investigation into the allegations so that you can then deliver a fair outcome to the employee. We'd always advise that's in writing, just so the employee has a written record of what's been investigated, and you take them through each allegation they may have raised, the evidence that you managed to collect as part of your investigation, and what the outcome is as a result of that. And the important thing as well is to always give the employee the right to appeal if they want to do so following that investigation.
Okay. And, when we talk about the grievance process, as Gemma pointed out, employers should have a policy in their employee handbook, but the grievance process is easily accessible via the ACAS website as well. Now, in terms of, the outcome of a complaint, who knows what that could be? There's a variety of outcomes, and that's why the investigation is so important. An outcome of the investigation could be that the individual faces a disciplinary hearing, and therefore the employer will then have to go through a disciplinary process, again in line with a policy, which is also available on ACAS, but should be available in an employee handbook too. And it could result in an employee being dismissed, or there could be an action for mediation between the parties, so there hasn't been a dismissal. It's really important that the investigation is completed thoroughly, because until you've done that, you can't determine an outcome. Well, one of the things that comes up in these investigations, and again, this is from my experience as an employment lawyer, I can tell you this, individuals that are accused of bullying or harassment or discriminatory behaviour, that one of the most common responses will be, it was banter. I didn't really mean for that person to take it that way. I've previously had laughs with them. There'll be those sorts of excuses and I will call them excuses, because individuals think if they say it's banter, or it wasn't intended to be offensive, or it was just a joke, that individual feel that they therefore should not be subject to disciplinary, and they should not receive a disciplinary sanction. And that is absolute rubbish. And I really need us to understand the difference between banter and discrimination, and when banter can turn into discrimination, when banter can turn into bullying. So the next question I'm going to ask Gemma is, what about banter, the famous excuse that we hear all the time?
So I think the first thing to mention is banter does have a place in the workplace. Ultimately, it can help colleagues have healthy relationships and helps sort of boost conversations within the workplace. But there is a line, and ultimately the line isn't, unfortunately, entirely clear, and employees can often step over that line. And as Tina mentioned, if that behaviour is related to a protected characteristic, that can lead into discrimination claims, or even if it's not related to a protected characteristic, can go into other claims, such as I mentioned, constructive unfair dismissal, if there's a long period of such bullying behaviour that an employee then reports and feels like they've got no choice but to resign as a result of that. So employees need to know the difference and how to conduct themselves. And again, training on banter versus discrimination is a really key training that all employees should undertake, just so they have greater awareness about that in the workplace. But I think at the minute, potentially the line is getting drawn and crossed too many times. As the survey represented, as Tina said earlier, 2 in 5 people say they're experiencing workplace bullying and harassment. And therefore, this excuse of banter really isn't actually what employees themselves who are facing these types of behaviours are feeling. And it's important to stress, as we mentioned earlier when we looked at the definitions, it is how the employee feels and receives that rather than what was necessarily intended. And so it really needs to be that employees are made aware of what the behaviours are, they're trained, there are clear policies in place, and appropriate action is taken by employers to ensure that it is called out and this behaviour is not tolerated within the workplace. So that will encourage more employees to come forward in the first place. And that, as Tina said, is going to have positive impacts for the workplace as a whole, on morale, potentially employees having better retention rates, not being off on sickness absence if behaviours have caused them stress or anxiety or other mental health problems. And it's also just going to be better for employees generally. So it is really key that this excuse of banter isn't relied on too heavily in these investigations.
So thanks, Gemma. So, just Gemma recapped on the stats, and, let's not forget, we found that 1 in 2 people believe that their workplace tolerates discriminatory banter. That is a shocking statistic. I can talk about this subject for much longer, but I appreciate it's probably time for me to wrap up now. But what I would like to leave you with is the phone number and email address, because if you're listening to this podcast and you're an employer, call us. If you're an employee and you're feeling a particular way about the way you've been treated, call us. So the number to ring for the month of November is 01926 732 505, or you can email us at callitout@wrighthassall.co.uk, and myself or a member of my team will have a 30-minute chat, and hopefully, this proactive action that I'm taking will achieve better workplace stats in the future, improve the culture of organisation, and end workplace bullying. Thank you very much for your time today.
Thank you.